Welcome to Law and Crime's Daily Debrief, everybody. The prosecution rests in the sex crimes trial of movie producer Harvey Weinstein. Law and Crime's Jesse Weber recaps the final state witnesses and looks ahead to what to expect from the defense.
Today we saw the continued testimony of Lauren Young, one of the Molyneux witnesses who claims that Harvey Weinstein trapped her in a hotel bathroom, touched himself, and proceeded to grope her. Under continued cross-examination, Damon Chironis kept hitting on those prior inconsistent statements in terms of what she initially told the district attorney or law enforcement and what she testified to, like using all of her strength to leave the bathroom, or pounding on the bathroom door, or Harvey Weinstein's alleged actions in the bathroom. Under redirect, Megan Hess was implying that the defense was mischaracterizing Lauren Young's statements, that she was in fact credible. Before the prosecution finished up with their case, Tara-Leigh Wolfe, another Molyneux witness, was recalled to the stand in response to an answer that she gave under cross-examination, more specifically about a conversation that she had with a woman named Gloria, where the defense seemed to insinuate that she was coordinating the series of events and timelines again to bolster the state's case. Tara-Leigh Wolfe seemed to deny this insinuation. Gloria Allred, who represents several of the accusers in this case, held a press conference outside the courtroom, and she had this to say.
I'm proud of my clients and their courage. They really were and are role models in courage. Very, very tough to undergo cross-examination by highly paid, experienced, small army of defense lawyers for a high-powered figure. And they did it. I don't think in any of the three testimonies of these three witnesses that I represent that the defense made any major impact at all. But that'll be for the jury to decide.
The defense then moved for a judgment of acquittal and mistrial, claiming that the state hasn't met their burden. They specifically cited Jessica Mann, saying that she consented to going up to the hotel room with Weinstein and having sex with him. Afterwards, Jonah Luzzi laid out her case once again, and the judge denied both of these motions. Now the defense is going to be proceeding with their case, calling their witnesses to strike at the credibility of the state's key accusers. And it's going to be interesting to see. We believe it'll last about 3 days, maybe more, maybe less, but it'll be something to watch. This is Jesse Weber reporting for Law and Crime.
We also asked Gloria Allred what happens if she is called to testify for the defense. Here was her response.
I'm aware they've attempted to serve a subpoena upon me. They decide they want to subpoena me and have me as a witness. As I say, that's good luck to them. They, I'll accept service, put me on the witness stand, and get ready.
Attorney David Ring of Los Angeles represents one of Weinstein's accusers. He's with us tonight from the West Coast. So, David, as Jesse Weber just reported, the defense called Tara-Leigh Wolfe back to the stand and attempted to say the accusers were coordinating an attack of lies against Weinstein. So here's your chance to speak for your client. Is your client, not Tara-Leigh Wolfe, but your client, involved in some kind of a coordinated attack of lies in this case?
No, not at all. My client doesn't know any of these other 6 women. She's never met them in her life, has never had even one shred of communication with any of them or any of their representatives. So I think the same holds true for these 6 other women. I think what the defense was doing there was trying to create some sort of smokescreen saying, oh, gee, she talked to someone to try to refresh her memory on exactly which year this occurred. Did it happen in 2002 or 2012 or 2013? That doesn't seem unusual to me for a victim to try to remember, was it in this year or this year?
We know Gloria Allred's answer to this, but what would you do if the defense tries to subpoena you to the stand in a case like this?
I'd be shocked if if Harvey Weinstein's defense put Gloria Allred on the witness stand. I mean, she is a savvy lawyer. She is not going to be tricked into giving some devastating answer in cross-examination. So, they're trying to serve a subpoena on her, but that might just be for show.
2 accusers and a group of witnesses to the other bad acts in this case took the stand. Does everything add up here to be guilt, or has the defense picked these stories apart to the point where the jury just can't believe the accusers?
Look, you've had 6 women testify in incredible detail about the power of Harvey Weinstein and how he sexually assaulted them. I mean, I think that testimony is overwhelming. There is some gray area on some of the victims for sure, based upon what their interactions with him after the alleged rapes. But overall, the prosecution has absolutely put on their case, and now it's up to the defense to put on their case, and I don't know what they're going to really put on other than some witnesses who try to attack the credibility of each one of these 6 women again.
If I'm reading between the lines there, I think you may be saying that there might be a chance for a split verdict. Is that your opinion, or is that not your opinion?
You know what? I look, hey, the reason why the jury gets to go back there and deliberate and look at all of the charges against each one of the charged victims is they can pick and choose, and they can say, the case was proven against this particular victim, but not against this one. There's absolutely a shot for a split verdict here.
The judge refused to dismiss any of the counts. Is that a surprise to you at all?
No, there's no surprise there. That's a routine motion made by a lot of defendants at this stage of the case. The defense knew that was going nowhere. They're really just making that motion to kind of go through the routine of preserving it for an appeal.
Attorney David Ring on the West Coast for us tonight. We appreciate your input on this case as you represent one of the accusers.
Thank you.
And to Ohio now, where testimony centered on bank records in the trial of a man accused of raping and murdering a young woman. Anthony Pardon is accused of raping, stabbing, and strangling Rachel Anderson on her 24th birthday. The lead detective discovered her debit card was missing and started tracking it.
What is this column right here that I'm pointing to?
Denied access.
So whether or not something was approved or denied by the bank?
Yes.
What's this column?
That's the limit, obviously limited, exceeded of the withdrawal, the denial reason.
Okay. Miss Anderson's card was denied?
Yes.
And what does this column show for those reasons?
Obviously the exceeded limit and incorrect PIN. She went to a lot of restaurants and used her card at a lot of restaurants. Bob Evans, Dairy Mart, Starbucks, Jimmy John's, Taco Bell, Panera, Wendy's.
Okay. So then later on, do we see a change in that behavior?
Yes.
And can you explain to the jury what we're looking at on the 5th page of K1?
You're seeing a lot of ATM withdrawals.
From there, detectives tracked the victim's debit card. The first place it was used was less than 2 miles from the victim's apartment. Surveillance footage tells the rest of the story.
What are we about to see happen?
You're seeing a vehicle pull into the lot from East Main Street.
Did you note anything of importance about that vehicle?
Yes. At the time of the viewing of this surveillance, we were at the location of the store, and we didn't know at the time, but that was Rachel's car, and we didn't know it was ever removed from the scene. So this is the first time we found out her car was used. You watch a gentleman exit through the passenger side of the car. It's Mr. Sleet.
Which side of the car did he get out of?
Passenger side.
During this video, did you observe anybody exit the driver's side door?
No. You're going to see a hand come out of the window and wipe down the side of the car.
Right there?
Yes.
Okay, so that was at approximately 4:39, and it's still happening,
Yes.
and now it's done.
Yep.
And as you saw right there, prosecutors say the defendant gave the victim's debit card to a panhandler named Anthony Sleet. Surveillance footage shows Sleet using that card at several locations. Sleet told police that a man presumed to be the defendant approached him and asked him to start taking suspiciously large amounts of cash out of ATMs using the victim's card. Then Sleet became shocked when he was told the owner of that card, the victim, was actually dead. That conversation during that police interview. At one point today, the defendant flipped out about the way his attorneys were handling the case.
Have you consulted with your attorneys? No. Okay, I just want to just make sure, anything that you say, particularly if it relates to any facts in the case, potentially could be used against you. So you just need to be careful, sir. But yes, sir.
A while back ago, I tried to get rid of my attorney. Under the advisement of the courts and other people, I went on and went through with this. But I'm telling you now, I am not happy with what's been going on. I'm not. I just want that on the record. I want it on the record that I am not happy with what's been going on here. I'm not. I'm also be sitting over there with them. I'm also be sitting right over there with them. I'm not happy with this here at all. I don't feel that I'm getting represented in no kind of 100% way at all. I want that on the record.
Okay. It's on the record, and yes, we did have the discussion previously, even though my recollection was that it was more so towards Ms. Dixon than Mr. Thomas. But we have it on the record that you're not happy with what's happening right now. I mean, we're not at a point at all where I can make that consideration whatsoever. Court of Appeals, if there is a conviction, obviously, we'll take a look at everything that the attorneys have done and decide if they have represented you appropriately in this matter.
Let's discuss what happened right there. Attorney Mike Korobanik's with me here in New York. So, Mike, give me a break. I think the defense has done an excellent job, a better than expected job representing this client, and he's complaining about them. They're raising potential doubt with the brother, maybe a little bit, with the other friends with whom there was sexual tension with the victim. I mean, and this looked like a really strong state's case off the bat.
Well, being a defense attorney at times is a very thankless job, and I tend to agree with you here. The defense is doing all they can. We don't make up the facts, it's what's given to us. And I think this defendant has such experience with the criminal justice system and hears all the other jailhouse lawyers. I always say have a guy who wears a suit, not a jumpsuit, represent you. And if that's who you're going to co-counsel with, he's getting these ideas, just make this record look bad, blame your lawyers, and you'll get an appeal. People don't realize appeals are not that successful. I think maybe 98% of them lose.
Exactly. That's my thoughts as well here. Well said, Mike Korobanik. Of course, we have two other attorneys watching with us tonight. Gigi Gonzalez is in Miami. Dina Dahl is in Los Angeles. So, Dina, what do you make of it here? Do you think that this guy has any leg to stand on complaining about his counsel at this point in this case?
Not so far. Like you said, the defense has already brought up some fairly good points. And whether or not he doesn't like his style, maybe he's not aggressive enough, sure, he could complain about that. But that doesn't qualify for ineffective assistance of counsel, which is basically what he's trying to say to the judge. And I agree that he has experience with the criminal justice system, and he knows, and he's hoping that saying it even during trial will actually help him out. It won't, but that's what he's hoping.
This guy's been in and out of prison since he was a teenager on rape charges. He's now faced with rape and murder. Gigi Gonzalez, sometimes defendants want extremely aggressive counsel. In a case like this, and in many cases, that just doesn't work. As a defense attorney, you want to make the jury inquisitive, and you always want to wear, as my trial advocacy professor used to say, the white hat. You're after truth, you're after information to help the jury make a decision. I think that's exactly what the defense is doing in this case.
Yes, they are. They are looking for every avenue through which they could raise reasonable doubt. They are trying to, question the investigator who is, on his case as to why not investigate other leads or other suspects. Now, that's an excellent, route for reasonable doubt. Like, why aren't you looking at other people for this? Why just him? I think that the defendant getting upset with his lawyers in this case is just his way of distracting from the overwhelming evidence in this case. I mean, his sister's going to testify against him pretty soon. So it's a very damning case with damning evidence, and this is a case of a defendant just throwing a fit at a last failed attempt to either extend these proceedings or raise questions as to them.
Well said, Gigi. Look, the defendant can complain all he wants, but the defense attorneys don't have control over the rules of evidence. That's what determines what gets into court. Still ahead tonight here on The Debrief, day 3 of testimony in the killing of a young Dallas mother. Officers approached the car she was seen sleeping in, and as the car began to move, 2 officers began to fire. Police testify the shooting was justified. After this. Day 3 of testimony in the Texas case against a Dallas police officer who fired his weapon 12 times while on duty and killed a young woman. Prosecutors are trying to convince a jury that Officer Christopher Hess acted illegally when he fired on 21-year-old Genevieve Dawes. The charge is aggravated assault by a public servant, and it carries a possible 5 to 99-year prison sentence. This is Officer Hess's body camera footage of what happened. A neighbor called 911 because Dawes and her partner were sleeping in the car. Police say they were suspicious because at one point the vehicle was reported stolen. The occupants tried to take off by backing up, driving forward, and then backing up again. Let's listen.
What's up? Alpha 143, check on major disturbance 2403 North Washington. Black male refusing to stay away from property. Wearing a black shirt, black pants with red on the carrying a backpack.
Back up, back up.
Heavy around the like security, their uniform and armed.
Don't move!
Hands up!
Shots fired! Shots fired! 4700 east side, back parking lot!
Cover code 3 Alpha 140, can you head that way? 4700 east side, shots fired.
Stop me an ambulance. Alpha 114, they rammed the squad car twice.
The defense called the lead Dallas police investigator to give his opinion about whether Officer Hess's use of force was justified.
I believe his use of force was reasonable based on everything factored in that evening.
What did you base that opinion on?
I based that on the fact that the officers were there for several minutes before the actual shooting occurred, had identified themselves multiple times, used lights, given instructions to show their hands, and yet Ms. Dawes proceeded to start the engine up, back up, strike the squad car, then accelerate forward, racing the engine, trying to break through the fence. So it appears she is trying to escape at a very high cost. And then backing up again into an area where at one point 2 officers had been standing, to the last of Officer Hess's recollection. Not unbeknownst to him, they had moved, but he did not know that. And he fired in defense of their lives, fearing that they were in jeopardy.
The defense then asked the lead investigator if he noticed anything important about the position of Officer Hess's head in relation to the other officers.
When he gets into the squad car, the engine starts on the stolen vehicle. He gets in the squad car to pull it forward. That's in the time in which the other officers that were behind began moving laterally, but behind Officer Hess. At that point forward, when the car backs up, the stolen car backs up and strikes the squad car, he steps out, he looks down briefly, then he looks, and his focus remains on that car. It is now moving, it has become a danger, a threat, it has struck the vehicle. He never looks to his left again. He would not have been able to know that those 2 officers had moved from behind the stolen vehicle.
On cross, the defense questioned the lead investigator about how he came to the opinion that the shooting was justified.
I cannot tell you what was in the defendant's head at the time, no.
You've conducted other criminal investigations before, right outside of the realm of Austin Wild shootings? Is that right?
Yes, I have.
You've interviewed suspects in crimes before, is that right?
Yes, sir.
You always take what they say at face value?
Not always, no.
Why not?
Sometimes I have evidence to the contrary. Sometimes suspects, tell me a story that's in their benefit to try and protect themselves.
Right. I mean, if they're accused of a crime, they don't have a motive to lie, is that right?
Yes, sir.
The vehicles are moving at the same time. She's moving in reverse as he's coming forward.
I have a hard time detecting the vehicle. Her vehicle's actually moving until after his is very briefly his comes to a stop, and then she backs up and strikes him.
Is it true that blocking in vehicles is a violation of DPD policy?
It is a violation of DPD policy, yes.
6 officers were on the scene, only 2 opened fire. The defense called the other officer who shot his weapon to explain why he did so.
The car kind of came back past the front end of the police car.
In the first volley of shots or the second?
On that first volley.
Do you know how many times you fired your weapon?
Just one.
Why did you fire your weapon?
Because when that car came across the front of that car, I was concerned that Hopkins was still behind the vehicle. But at the time I pulled the trigger, I believe he was still standing back there.
Where were you? Where did you believe Hopkins was?
Right over here, this area.
Why did you think he was there?
Because when I crossed in front of him, I mean, it was just seconds later is when the car came across the front of the police car. And like I said before, when that car's coming back, I'm concentrating on that car, not on where everybody's at.
Why did you make the decision to pull the trigger?
because I was worried Hopkins was going to get hit by that car.
Did you believe that Hopkins would get hit by that car?
Yes,
Why did you believe that Officer Hopkins would get hit by that car?
because the last place I saw him was directly in the path of that vehicle.
Let's turn to our guest attorneys one final time tonight. Gigi Gonzalez, I'll start with you in Miami. Here's what bothers me about this whole scenario. Let's toss aside for a minute that the defendant may not have known where the other officers are. Let's toss aside that the vehicle barely moved. I listened to that video, and here's what happened. You hear the police tell whoever's in that vehicle to show their hands, and then you hear the phrase back up, and it's seconds later that the vehicle backs up. And then you have the officer get up on the stand and testify, the detective who's overseeing this whole thing, saying that this is an escape. If I'm the prosecution, I'm going to get up there and say, no. The people in that car heard the phrase back up and they thought that applied to them. Is that reasonable or is that unreasonable?
It's reasonable. Look, listen, you told them to back up. They are complying with your official orders. Now you have a cop car that gets in the way, and you have 6 officers that got their guns drawn on you. What are you supposed to do in this situation? You don't do what they do, they might shoot you. You do what they do, they're going to shoot you. And in this case, they did what the officer said and ended up with a bucket of bullets inside the car, leading to the death of a 21-year-old young woman, a young mother. This is very sad. This is a case of overkill, and it's an abuse of power.
Dina Dahl, your thoughts on this one? Because I'm looking at it and I'm guessing that they meant back up, talking to another officer. But if somebody in that car heard that, that's the issue here.
Yeah, I think that's an excellent point. And I saw they have a diagram there in the courtroom. And this case is tragic. But it is going to come down to those very specific details, the footage, the perspective of the different officers. And I could really see it going either way. I mean, we just did the case with Trooper Casey, where he was shot in what was like a very routine stop. And he did everything by the book, unlike maybe these officers. But he was ultimately shot. These kind of situations are dangerous for the police officers, and now we know, unfortunately, dangerous for some very innocent.
Exactly. Hey, Dina, we've got to wrap things up here on the debrief. I'll see you back here tomorrow at 5 o'clock.